This Honorable Court of Criminal Appeals is now in session.
Good afternoon. This is the May session of the Court of Criminal Appeals in Nashville. The panel is Judge Robert Montgomery from Sullivan County, Judge Tim Easter from Williamson County. I am Norma McGee-Ogle from Sevier County. Each side will have 20 minutes for your argument. If you would like to save any time for a rebuttal, please let me know before you begin your argument. Please call the first case.
Rohman M. Harper versus State of Tennessee.
I should say the case.
Your Honors, may it please the court, Andrew Mills of the Dickson County Bar. I represent Rohman Harper in his appeal as of right from the Cheatham County Circuit Court on his petition for post-conviction relief. I would respectfully request 5 minutes for rebuttal.
I will note that.
Thank you.
You may begin.
Your Honors, the issue presented before the court is whether trial counsel's failure to obtain and call at trial an expert witness in psychosexual evaluations over the wishes of the appellant constitutes both ineffective assistance of counsel and prejudice to the appellant under Strickland versus Washington. Now, the trial court did not agree that it was either ineffective or prejudice to the defendant, but the appellant disagrees with that and is respectfully appealing to this court. As this court is aware, under Strickland v. Washington, any petitioner for post-conviction relief must satisfy both prongs. The first prong is whether or not trial counsel was ineffective. I will address that issue first before the court today. The second issue is whether or not, assuming arguendo that it is ineffective, whether or not that was prejudicial to the defendant. Would it have made a difference at trial? Regarding the first issue of whether or not trial counsel was ineffective, I would like to point out a few salient facts for the court before I get into more of the argument and the law. Mr. Harper, the appellant here, was found guilty of aggravated sexual assault in 2013, as well as a couple other misdemeanors. But that was the main charge. He was sentenced to 8 years to be served at 100%. Trial counsel for the appellant, Mike Flanagan, who is an experienced trial attorney. I think he testified that he, at that time, had tried over 417 cases. He did not prepare a defense as to the aggravated sexual assault. He did not prepare any witnesses or any rebuttal evidence. It is contended before the court, based upon the record at the post-conviction hearing, that the appellant requested a psychosexual evaluation or some other evaluation to rebut the sexual contact element of aggravated sexual assault. Mr. Flanagan, the trial counsel, refused to do so. After conviction at the trial court level before sentencing, the appellant obtained his own psychosexual evaluation from Dr. Walker. Dr. Walker was one of the primary witnesses who testified at the post-conviction relief hearing. Dr. Walker was certified by the court as an expert in neuropsychology and psychology. He testified that he was a licensed psychologist and until recently was the chairman of the Treatment Review Committee at the Tennessee Department of Corrections. So he was certified by the trial court and admitted as an expert in both of those fields. He discussed, as is pretty well outlined in both my brief and the state's brief, a series of tests upon the appellant to determine basically the findings for a psychosexual evaluation. And he found, and this is probably the most salient detail, quote, that the appellant did not have a sexual interest in children or homosexual interests. So those, I think, are the salient facts, and I can certainly answer as to any others. But looking to case law, looking to what this court and the Tennessee Supreme Court and the U.S. Supreme Court has found in these types of cases, we must eliminate the distorting effects of hindsight. We have to look at what would the court, what would the state, what would the defendant and the trial counsel have done at the time. We can't play Monday morning quarterbacking. We have to look at it when it happened and was a decision that was constitutionally prescribed made. Not the best defense, not a perfect defense, but was it required? So we have to eliminate the distorting effects of hindsight, and there is a strong presumption that my client, the appellant, must overcome in that trial counsel's assistance is presumed to be reasonable. There's also a deference by this court, as has been espoused on a number of occasions in your opinions, that trial strategy and tactical decisions must be left to trial counsel. So, to this first prong of the Strickland versus Washington test, is obtaining and then calling an expert witness when requested by a criminal defendant, is that on one end of the spectrum, is that trial strategy? Is that a tactical decision? Or is it closer to the other end of the spectrum where, as this court is obviously well aware, a criminal defendant has a right to go to trial. He has a right to testify. He has a right to call witnesses. Is it within the penumbra of that right to call witnesses? Can a trial counsel refuse to go get a particular type of witness when a criminal defendant asks? That is really this first question before the court today. And I would also submit that this is an important question for the criminal defense bar. I may have missed it, but I could not find a case that this court has opined upon with this direct issue. There are guiding cases, but I did not find anything on point where a defendant requested a particular witness, especially an expert witness, and trial counsel refused to do so. So I think clearing that up, however it's decided, and of course we would submit that it is a right retained by a criminal defendant to call certain witnesses, but clarity will help the bar and eliminate issues in the future. So I think that outlines our argument in addition to our briefs on the first prong. The second prong, assuming arguendo that this court finds that trial counsel's assistance was ineffective, was it prejudicial? Did it have a prejudice upon the appellant, and would the outcome of the trial have been altered? This court opined, as we discuss in our brief in State versus Zimmerman, that evidence stemming from a failure to present witnesses must be significant. And the court said that significant meant, would it have had that prejudice? Would it have led to that prejudice? But it's not whether or not he would have gotten a not guilty verdict. It's would the outcome have been different? Put another way by this court, would there have been a reasonable probability of being found of guilty of a lesser included offense? In the case before you today, we are submitting to the court that Dr. Walker's testimony had a reasonable probability of altering the case. There was no evidence presented to rebut the sexual contact element of aggravated sexual assault. The appellant did testify on his own behalf, but there was no one else to testify as to that element. If someone was able to educate the trier of fact as to that element, it could have led to a lesser included offense. So we are arguing before the court today that would have made a difference, that there was a prejudice by not calling this expert witness. I will point the court to 39-13-504, where sexual contact is actually defined. And I'm going to quote from the statute briefly here. It is the, quote, intentional touching can be reasonably construed as being for the purpose of sexual arousal and gratification. The appellate submits to the court that this is about the mens rea of a criminal defendant. We are not today questioning the actus rea. That would be for a new trial if the appellant got one. The act has been testified to. We're not getting into the actus rea, we are talking about the mens rea today, and that would be the sole purpose of Dr. Walker testifying to educate the trier of fact about the mens rea. If you recall from earlier, if the appellant had no sexual interest in children and no homosexual interests, the victim in this case was a young boy. And I'll be the first to admit that these facts are grisly, but it's not the facts per se that matter. It's this principle that we're getting to of who has the right to call these types of experts. But getting into the facts as are necessary for this case, if the appellant, was incapable of having sexual gratification, it should have been aggravated assault. Being able to address the mens rea through an expert is permissible. Now, the trial court and the state both cite State v. Campbell. The appellate submits to this court that that case and the line of cases that it represents addresses whether or not an expert can testify as to certain behaviors, whether it be about the victim or the criminal defendant. I think that case and the cases like it are excluding properly experts when they are trying to testify about the act itself. What we are talking about today here is the very narrow issue of the mens rea. What can an expert testify to? And I think Dr. Walker being able to testify about a criminal defendant's sexual gratification and arousal would be allowed, would attack the mens rea, would attack an essential element of the offense. So, based upon those two factors, we are submitting to the court that both have been met, that trial counsel was ineffective by not obtaining and calling an expert witness at the request of the criminal defendant, of the appellant here, and then that failure to obtain and call that expert witness prejudiced the defendant because he could have attacked an essential element of the case, and there is a reasonable probability that it could have led to being found guilty of a lesser included offense. And once again, I will note for the court that I think this is an important issue for the criminal bar so that we know in the future if one of our clients requests a certain witness, are we compelled to do it? Again, is it in the penumbra of a right to call witnesses, or is it clearly within trial strategy and tactics and it should be left to the trial counsel? That is what we're seeking clarity on, and we are asking the court to reverse the trial court. I'll defer to Ms. Smith. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Colleen Smith on behalf of the state. While the petitioner argues that the court erred in denying his petition for post-conviction relief, the court properly found that Dr. Walker's testimony would not have substantially assisted the trier of fact. Starting with the court's citation of Campbell, Dr. Walker's testimony addressed the petitioner's propensity to sexually abuse young boys. Such propensity evidence would not have been helpful to the jury, and Tennessee courts have consistently rejected the admission of expert testimony pertaining to behavior characteristics of offenders to show a propensity to commit a certain crime. Here, the victim and Ms. Crutchfield both testified that the petitioner put his hands down the victim's clothes on his penis. The petitioner testified that he did not think that he had done this, although he said that he might have done it because he was blackout drunk. He likewise testified that he did not know why anyone would put their hands down a 6-year-old's pants unless it was for sexual gratification. Dr. Walker acknowledged that people who are under the influence often do things they wouldn't normally do. And he testified that it was entirely possible that the petitioner had committed the crime while under the influence without any permanent predilection toward children. This testimony does not refute the mens rea of touching the victim's penis for sexual gratification. The petitioner also disregards Dr. Walker's testimony that the petitioner told him that although he had consumed alcohol on the day in question, in no way was his memory impaired from the start to the end of those events. Dr. Walker admitted that he had not read the petitioner's trial testimony, in which he testified that he had blacked out and didn't remember much of what had happened. Dr. Walker also acknowledged that the petitioner specifically denied that there was any way that he had committed the act, contrary to his trial testimony that it was possible that he had done it. And Dr. Walker explained that sex offenders often lie due to their shame. This testimony refutes the petitioner's claim that Dr. Walker's testimony would have caused the jury to find that he did not touch the victim's penis for sexual gratification. The court properly found that the proposed testimony would not have substantially assisted the trier of fact, and that the petitioner had not established that counsel was deficient for failing to call Dr. Walker at trial. Additionally, trial counsel testified that in his 35 years of criminal defense experience, psychosexual evaluations rarely come back favorably to a defendant in a sexual battery case, and he did not want to create evidence that would be unfavorable, that would be discoverable by the state. This strategy was informed, it was based on adequate preparation, and it's entitled to deference. Additionally, the petitioner disregards Dr. Walker's serious disciplinary history. His medical license was suspended in 3 states due to his addiction to heroin and cocaine. Coupled with Dr. Walker's testimony that the petitioner had presented conflicting information regarding his memory of the events and whether it was possible that he had done it, the petitioner cannot show that the court erred in finding that Dr. Walker's testimony would not have substantially assisted the jury. And regarding the petitioner's claim that he could have remained silent had Dr. Walker testified, he acknowledged that it was that counsel let him make the choice to testify at trial, and he didn't provide any testimony at the post-conviction hearing that he chose to testify due to counsel's failure to present Dr. Walker's testimony. The proof shows that he chose to testify of his own free will. If there are no further questions, the state respectfully asks that you affirm.
Thank you, General. Mr. Mills?
Your Honor, thank you. Well argued. I would like to rebut a few of those issues just raised. I believe I addressed most of these in my reply brief, but I will highlight a couple for this court. First and foremost, regarding Dr. Walker's past, it is a checkered past, but all of the issues that Dr. Walker had were after the psychosexual evaluation was done in 2013. So, again, we're asking this court, and this court has opined before, not to let hindsight be 2020, to look at what it would have been at the time. And in 2013, Dr. Walker was the chair of the TDOC board for psychologists and was a licensed psychologist and neuropsychologist. So I don't think that that's relevant for this court. Secondly, regarding the defendant, the appellant here, calling the witness or not, it was his decision to make, just like it was his decision to go to trial, just like it was his decision to testify. Sometimes an attorney has to live with that. I've had multiple cases where you try to convince your client not to testify, and they do. That should be, the appellant submits, that should be no different here with expert witnesses. I will also add, as we stated in our reply brief, the state at the original post-conviction relief hearing did not object to Dr. Walker's testimony and did not conduct any discovery. So any argument on that front is waived. Finally, regarding
Mr. Mills, did the state know that you were going to be calling the doctor at the initial hearing?
Your Honor, I don't think it's in the record, but they did. I mean, it wasn't, a month ahead of time, but I have a good relationship with the DA.
I thought that was the reason that the state asked for an opportunity to come back the next day or sometime later, was because they didn't know that Dr. Walker was going to be called at the initial hearing. Is that not true?
I refute that, Judge. That they were aware and they didn't object. They sent me no discovery. So we prepared our witnesses. We got them ready. And I would submit that the reason that the state tried to reopen the PCR hearing, which I think was flawed to begin with, but not really relevant here, is that they found some of these issues that the state was just talking about and wanted to raise them at that time. But again, I think if we're going back to hindsight is not 2020.
Well, let me ask you this.
Yes,
Did
ma'am.
the trial court or post-conviction court make any specific findings about whether or not the state had been given notice when making its decision to allow the reopening?
If memory serves, I don't have the order in front of me, Your Honor. If memory serves, Judge Wallace reopened the hearing out of an abundance of caution to have something on the record. I believe, looking at his opinion, he didn't even rely upon that. He looked at State v. Campbell. He felt, like the state argued here, that it would not have been allowed, therefore it's not prejudicial, so I'm denying the petition. I don't think the court got into whether or not there was notice, and frankly, upon my reading of the court's order, that second hearing wasn't even taken into account. So, Your Honors, I know that this is, again, the facts are not favorable to my client. It's not a sympathetic case, but again, I submit to this court that whether or not a criminal defendant has the right to request of his criminal defense counsel an expert witness, who gets to decide that is important. The appellate submits that it is a criminal defendant's rights to do that. State takes a different position. It's for this court to decide. But in sum, we are respectfully requesting that this court overturn the trial court and order a new trial. If there are no further questions, that's all I have.
Thank you, counsel.
Thank you.
That concludes this case, and court's ready to recess.
This honorable court is in recess until 2 p.m.